Greetings and salutations. Welcome back to another episode of the Legal Beagle. Today we're talking with Gopher Gold from our Telegram group. She has chosen not to be on camera or to reveal her real name, but she's going over a declaratory judgment that she has filed in the Pennsylvania State Court, which has now been transferred to the Supreme Court because they didn't have jurisdiction. She was trying to record courtroom proceedings, and they threatened someone else in the courtroom with arrest if they were recording, while the police officers and the lawyers were able to use their phones in any manner that they wish. So she's asking for a declaration of her rights from the Supreme Court, and she's about to file those briefs. But very interesting conversation we had today. Is a great way to get started. If you're just getting started, it teaches you how to write and gives you some experience in the courtroom and the judges and lawyers and these type of things. And so it's a great way to get your feet wet, dip your toe in these things if you want to get started with something with no risk. So this is a great tutorial on how to do that. And I hope you enjoyed as much as I do. Here, without further ado, here's Gopher Gold. Welcome, Gopher. What's going on? Tell us about it.
Well, from the Commonwealth of Pennsylvania. We are a state known as the state motto used to be called the state of independence, and now we're the state where you can pursue your happiness. But I don't know, that happiness has gotten a little strange lately.
It's all in your definition of happiness, right?
Exactly. So I have something to share that I've been happy to pursue for the sake of getting our republic back, but it's an arduous process. It's called a declaratory judgment,
Okay.
and yeah, and I had a court watching experience, which led me to write it.
Okay.
So,
Well,
yeah.
tell us a little history on that. How'd you get into it? What, or how'd you find us, and et cetera, et cetera.
Oh, how did I find the Telegram groups?
Yeah.
Yeah. Well, it started in 2021. I got an email saying that there was going to be this law summit, and I thought, oh, that's kind of interesting, because I had been studying on my own years before, encountered, patriot mythology stuff, didn't quite understand it, so didn't go over any further. Um, and I ended up watching it, and that's how I met Alphonse. He was one of the people interviewed in that summit, and so I joined his channel.
Hey,
And that, yeah.
go ahead. Can you tell us a little bit how you broke out of the patriot mythology?
Well, it never made sense enough to me. Go after land patent. Okay. I live in a state that's got history since the 17th century. How am I going to get my land patent? I don't know. And uh, just it just didn't seem like I could follow through on the methodology and know that it was legit.
So a detailed person, trying to find the source materials for the facts, decided
Yeah,
maybe this isn't right.
it just didn't sit right.
Yeah. Now, I will tell you. Now, Benny just came on and talked about land patents, and in Florida, apparently there is something to it, But overall, it's not something I've ever seen in court documents or any court case law that I've read. So, we'll see where it shakes out with people doing research. But for now, it doesn't seem to
Yeah.
be valid.
Well, I think it's always good to know the history of something. In fact, I'm an early American history buff, and I'm learning how the law was brought over from England to this country, and how people viewed the law, like fundamental law. And so it's really good. It's really grounding my understanding and my authority, so to speak, in what I'm doing. Land patent might have offer some kind of understanding um, that will be useful, but it's a work in progress. Always learning something new here.
Yeah, and that's what our educational series has started with. Basically,
Yes.
just kind of getting us from England into and what's happening in this reality and why we've gotten to where we are. And before we even go into the fundamentals of how to write a complaint and these type of things, that's what we wanted to start with too. So I think it's a good foundation. I think you're right. So
Hmm.
tell us about your court watching experience and what got you so mad you
Well,
wanted to write
y-
something.
yeah. Well, even before that, so I was listening to Alphonse, and oh, okay, I have to study the law as in black and white. That made sense. And I went to a school board meeting to oppose the mandatory masks, even though I don't have children in school anymore. But I wanted to support that effort. I know there were parents who were going to be at this board meeting, and of course, I was forced to wear a mask, but I resisted, and they called the police on me. And this police officer was very nice. He just said, "Ma'am, I don't want to arrest you. Just, I know this is wrong. Just put it on and go to court." And so I didn't know how. I know I wasn't trespassing, but I didn't know how to fight it if I didn't want to get arrested. So, and then 3 days later, I'm driving out of state and I get pulled over by a law enforcement state trooper who was the most unprofessional, agitated jerk I've ever encountered. And that got me started even more so. I didn't know how to handle that situation other than I got the ticket and then fought it from there. And that's a whole nother experience. That was in 2021, and then the COVID crap came. My husband's employer was forcing the jab, and I got involved in telling the employer to go pound sand for my husband's sake, and that took another several months to go through. And then I started property tax research, and that was in 2022, and then um, in 2023 is when I had the court watching experience. So I went to a municipal court um, in Pennsylvania and witnessed. Well, first, I was sitting there and I walk in the courtroom and I see two signs: no cell phone use and no recording without court's permission. The judge comes in, and I'm noticing that there's well dressed people using their cell phones, and even police officers in the back. And I said to the man next to me, "Hey, the sign over there says no cell phone use." And he said, "Well, I'm a lawyer." I'm like, "Oh, okay." And then I had a constable come up to me and say, "You're not recording, are you?" Like reaching into my space with her head. And I'm like, "No." Well, she didn't say that to anybody else who was using their cell phone. Cell phones have recording capacity, so why didn't
Sure.
she go up to anybody else? And why was the sign there that said no cell phone use, but you could use your cell phone? And the judge, when he came in, he didn't say anything. So then the session began, and there was a defendant who was exercising the First Amendment right to record, and that judge almost arrested this person for recording the hearing.
Yeah, it's a bit of a double standard. The court absolutely can bar recording devices, but if anyone is allowed in with a recording device, then you are too under equal protection, which is the same situation we're in with the U.S. Marshals here, right? And so we've challenged that as well. And now, when do we get a ruling or move forward? No telling. But yeah, so it's definitely unequal treatment. If you're a member of the bar, you have different rules than if you're a member of the public, which cannot be.
Right. And the signs there, no cell phone use. It doesn't say except lawyers and police
Right.
officers.
Right.
So yeah, and then I tried to get the a recording of the transcript. I mean, of the session, and I was given a CD by the court, and it wouldn't play. I got it home, and it just doesn't play. And I called the court, and I said, "It doesn't work." And she said, "Oh, you need special software." And I said, "Well, what software is that?" And she said, "I don't know. Take it to the library. See if they can do something for you." Well, on the jacket of the CD, it says for private use only. Do not use it out in the public. Well, a library is a public space, so I didn't want to go to the library. I didn't see that it was accessible. She can't tell me what software to use. It's just crazy. Um,
And what was your interest in viewing this courtroom proceeding?
well, it's just to testing that the public has accessibility to public courtroom events.
So you didn't know the defendant or anything. You were just in there auditing.
Yes,
Okay.
just one of those days. Um, and so, yeah, you see on this Rumble interview with Robert Barnes.
Hmm.
He mentions, I don't know if it's the same case, but I'll just play.
We got crazy cases out of Pennsylvania. Not only update on the Amos Miller case, we got people who are today in prison in jail in Pennsylvania, though they have never been charged with a crime, and though they have never been made parties to it. And yet courts, at some level, complicit with a state, a rogue state agency, has ordered their imprisonment with no set determination of what to do. By a court that doesn't even have criminal judges that signed off. It's the court that's going to handle the appeal in the Amos Miller case. So you got to wonder what's going on there. We have another case where a woman has been charged with a crime for reporting her own court proceedings. So we got that going. We have the Supreme Court.
So there. I don't know if it's the same case, but then you just hear Robert Barnes saying there's a lot of madness going on in Pennsylvania, although I'm sure it's happening in all the other states as well.
As you and Alphonse are acutely aware.
Yeah. So, um, and then in the Amos Miller case, the constables were collecting pens, paper, and pencils from everybody.
I heard that. That is crazy.
Yeah, it's just gotten so out of hand. But the point is that these public officials are committing and lawyers are committing all kinds of crimes, and they have to hide it, cover it up, so they commit more crime to cover it up. So I'm sure that the courts do not appreciate my declaratory judgment. It got transferred. I started in the Commonwealth Court, and now it's up at the Supreme Court, Pennsylvania Supreme Court.
And so, can you tell us a little bit about a declaratory judgment and what its purpose would be?
Yeah. Well, I'm going to get to that, but I
Okay.
like in learning what Alphonse recommends. Do those record requests, and that's what I did, and I got perfect. I got perfect evidence that's going to set that just puts their crime in the limelight. So so it's a good thing I did that. Um, so let me show you. Let me go back to yeah. So well, let me explain. I did the record request, and I was told that there are certain rules of procedure that they're following. Um, let me just so I asked these questions. Please provide the legally and lawfully promulgated records a municipal judge relies on to prohibit cell phone use by the public in a public courtroom while attorneys and police officers are exempted. Two,
Hmm.
please provide the legally and lawfully promulgated records a municipal judge relies on to prevent anyone, whether the public as quiet court watchers, a defendant, a plaintiff, a prosecutor, from recording a public session. Three, please provide the legally and lawfully promulgated records a municipal judge relies on that allows a court to lack or deny an official court reporting of the public sessions. And I was given the answers that the Rule of Criminal Procedure 112 and Rule of Judicial Administration 1910, as well as an administrative order in 2016, was the answer to those questions. That's
Hmm.
what I was told, but no, they're not. So here's the 2016 administrative order into that all photography, video recording, audio recording inside the Chester County Justice Center in any area beyond the security checkpoint is prohibited, absent authorization. So that goes against the First Amendment. Um, and if you look at
Well,
the
just so you know, judges do have the authority to ban these things if it controls the courtroom for a particular case. Now, what's required for that is they have to have jurisdiction over the individuals, and there has to be has to be in session of court, right? And they can control not only the courthouse or the courtroom, but the surrounding area as well if they need to, if it's going to influence an ongoing case. However, if they're going to allow lawyers and officers in with their recording devices, they can't ban the public. It's just like just like guns. They can ban guns from the courthouse, but it would have to be the law officers couldn't bring it in either. They don't have any special power just because they have a badge and sworn an oath. That matters not.
Okay. Um, and the Supreme Court has said that public events can be recorded. Is that also included?
Well, right, but so a trial is public to some degree, but if the judge thinks that it will influence the case, he can ban certain, but he would have to ban it for everyone. He can't just say selective people. That would be discrimination.
Okay. Is there any distinction too, like when you have, say, like a commercial entity, like a news uh, caster coming in, where it's could cause some chaos, to bring in all that equipment and
Sure.
so I mean to me that's kind of how it makes sense is when you bring in more of a fanfare for commercial purposes that it can muddy the proceeding. Um, whereas as someone sitting quietly in a courtroom, how is that interfering with the session? They're being
Well,
quiet,
Well, there are a lot of factors. If it's going to taint a jury pool, if it's going to things in the press that they don't that's supposed to be under seal or indictment, each case is different, and the judge should have very valid reasons for doing what they
Yeah.
do. But
Okay.
again, you can't pick and choose who you allow recording devices in. It's either they're allowed or they're not.
Okay. So Rule 112 is all about publicity, broadcasting, and recording of proceedings. Um, so, and rule same thing for 1910. Um, you can't use an operated device to capture, record, transmit, or broadcast a photograph, video, motion picture, or audio of a proceeding or person within the facility. Then the appeal, let's see, the appeal. Oh, so from doing the record requests, I appealed. Yeah, I appealed the answer I got, these rules. I said, okay, well that doesn't answer my question. Why can police officers and lawyers use their cell phones, but that has recording capacity, but the rest of us, well, I could have used my cell phone if I wanted to. Apparently, that sign means nothing. But I was asked why. Make sure you're not recording. Um, so I got this answer back from the president judge of the Court of Common Pleas. So he repeats again the rules. Let me make this larger. Is that better?
Mm-hmm.
Rules 112 and 1910. And he admits that a defendant may cause a recording to be made of the judicial proceeding as an aid to the preparation of the written record for subsequent use in a case. Okay, so I witnessed a defendant under threat of arrest for doing that. So that fueled my petition.
Gotcha.
So when it comes to a petition, declaratory judgment petition. You can go to this website and learn all about what it does, why do it. Okay, so this explains the Uniform Declaratory Judgment Act, reason for its adoption. And I highlighted, let me make it bigger.
And what site is this from?
It is from this site, uniformlaws.org.
Okay.
And it reads, you can just download it and copy it to your desktop. It should be the primary purpose of the state to save its citizens from injury, debt, damage, and penalties. And to this end, the highest function of the court ought to be to decide, when possible, the controversies of parties before any loss has been suffered or any offense committed. So, voila, there. I had to amend it twice because I made mistakes in learning how to do this. Um, uh,
So
and I, yeah.
basically, this is you see a wrong, and you ask the court to before it's a problem to declare what the law is.
Yes, but also I have to have it has to involve me. I can't be doing it for somebody else.
Right.
So, yep. So I'm not giving a cause of action. I'm asking what are my status and rights in this situation, where I read a sign that says no cell phone use, and yet people are using cell phones. And I have a constable come up to me for not record, and T all right, so what you're telling me is a courtroom, a judge can control things, but in that situation, I was just I don't think there was any reason to prevent recording, um, by the courtroom, and then the fact that I can't get the CD to play, um, so I don't have access, so, I
Yeah,
don't know.
probably all by design. But this is a perfect example of how people can dip their toe into this and not have any risk or recourse if if things go poorly. But this is a perfect example of what you can do to get started.
Mhm. And because you're not giving a cause of action, you're supposed to be able to avert a motion to dismiss. But of course, that's what the lawyers, I call them liars. That's what they do. It's like they don't even know what a declaratory judgment is. That it's different from a complaint. Without a cause of action, you're not looking for monetary damages. So they write up a motion to dismiss. It's called the preliminary objection in Pennsylvania.
Mhm.
And they just throw spaghetti at the wall and see what sticks. So I'll show you what this particular
Well,
lawyer did. Uh, Go ahead.
well, in essence, you are attacking the bar and their privileged rights, so they're going to be up in arms about it.
Yeah. So Title 42, Pennsylvania Title 42, Subchapter C, Declaratory Judgments. I can't make it any bigger, but I'll just read. Um, Section 7532. Courts of record within their respective jurisdictions shall have power to declare rights, status, and other legal relations, whether or not further relief is or could be claimed. No action or proceeding shall be open to objection on the ground that a declaratory judgment or decree is prayed for. The declaration may be either affirmative or negative in the form and effect, and therefore, it's such shall have the force and effect of a final judgment or decree. So that's explaining what it is.
So there's an option. It looks like to me to put in a motion to strike on their objection or whatever they put in as a response to it.
Yeah, so that's what I'm learning now. I should have struck it because there should be whether or not further relief is or could be claimed. No action or proceeding shall be open to objection. I didn't see. I'm learning as I go.
Sure. Well, that's great.
Yep. So that's why this is real good practice. Okay, and then in subchapter D, jurisdiction of Commonwealth Court. That's the court that I sent my petition to. They have original jurisdiction of all civil actions or proceedings against the Commonwealth government, including any officer thereof acting in his official capacity. And then it gives exceptions, but none of them apply to me because they were in the nature of the writ of habeas corpus or eminent domain. Not nothing really. So have. I thought I was correct in sending the petition to the Commonwealth government. Court. Um, but then read further in section 7533 of Pennsylvania Title 42. It says any person interested under a deed, will, written contract, or other writing constituting a contract, which that's not me, or whose rights, status, or other legal relations are affected by a statute, municipal ordinance, contract, or franchise, may have determined any questions of construction or validity arising under the instrument. Well, I realized, okay, I didn't have a statute, a municipal ordinance, contract, or franchise. I had a judicial rule. So then I thought, okay, that's why the Commonwealth Court ordered that it didn't have jurisdiction and sent it to the Supreme Court of Pennsylvania, because the Supreme Court of Pennsylvania is the only court that has the authority to oversee the judicial rules. So that's where I guess is legitimately why the petition is now with the Supreme Court.
So here you are at the top of state court.
Yes. Yes. And I wasn't planning on expecting that. I was expecting to have to do that on my own. So, to appeal. But the Commonwealth Court did it for me. And so I would say I survived the motion to dismiss.
Sure.
And I'll show you the order because it's funny how they wrote it up. So like they're pretending to uphold it, like we uphold this preliminary objection, but we're transferring it. So yeah, in Pennsylvania, there's the Rule 1028 preliminary objections. They follow the same federal. Was it Rule 12 on the federal? For all the motion to dismiss reasons: failure, insufficiency of pleading, lack of jurisdiction, failure to conform, blah, 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 or lack of capacity to sue.
Yeah,
all
standing,
those were,
right.
Yeah, no standing. All those were thrown against me.
But you're not suing.
Well, that's what I don't understand. They consider I'm not suing for monetary damages, but
right.
but I'm suing for what's my status, what's my rights here.
Right. So
is it the same thing? I don't know.
It's like an injunction. An injunction would be, you would have to have been harmed, but in this particular case, you could potentially see a harm and ask the court to strike the record before, or give you a decision before you had to go in there and get harmed. And I think that's the avenue differently than the injunction. But in the injunction, you would have to have been harmed. They would have had to take your recording device away from you and whatnot. So this is a subtle difference, but it's very interesting. And I don't think the federal courts would rule on these things without an injured party. But anyway, this is great. This is absolutely wonderful.
Yeah, and it's the federal legislature, Congress, that adopted the Uniform Declaratory Judgment Act, and then the states followed through, and so each state created their own act as well.
Mm-hmm.
And this is a great article here. The Uniform Declaratory Judgment Act, reason for its adoptions, will nicely explain what.
And if you'll send me that link, I'll add in the show notes after this.
Oh, okay. All right, I will do that. And the other thing is, it's good experience in writing documents. Um, there is stages that like there's no discovery, there's no oral arguments. You just write the petition, the respondent responds, then there's the briefs. You write the briefs, and then the court rules. So
And
it's
what stage are we at now? So it's just submitted and we're waiting on the Supreme Court, or?
yes, and I've gone through, and you see all these tabs up here. So I've got to just share um, the steps, all the documents that were written,
Okay.
both
Okay.
mine and the lawyers. And now the Supreme Court has to rule, and it probably won't rule until next year. Because, like I said, I started this in um, June 2023, or April 2023, and now it's April 2024 when I got the notice that they were transferring the case to the Pennsylvania Supreme Court.
So they delayed it in the lower court as long as they could, and then pushed it
Yeah.
up. That makes sense. That's what's happening all over the place.
Uh-huh. Okay. So then let's see. No, let's go back. Okay, so there is my petition, and I need to know. Let's see. I'm declaring. I want a declaration of my rights and further relief because of the facts, conditions, and circumstances that I describe. I need to know and abide valid and legitimate rules by which justice is obtained. I seek specific and direct answers regarding the use of cell phones and the recording of courtroom proceedings in relation to the First Amendment. Since I'd been denied access to court proceedings, witnessed a threat of arrest, and encountered difficulties in finding answers using the right to know law, and appealing to the Court of Common Pleas. So I witnessed and experienced contradictory and arbitrary adherence to courtroom rules between those posted or verbally enforced by executive orders and those by statute. So my questions were, and so I'm thinking that gives me my standing right there,
Mm-hmm.
right there. So my questions are: must the public citizen shut off the cell phone use while lawyers and police can disobey in plain view of a judge who posts a sign that prohibits all cell phone use? And two, does the courtroom participant have the right to record under the First Amendment? What role they're in.
Mm-hmm.
And so I wrote it up like a complaint. I have my jurisdiction and then my allegations with judicial notice. So I just start, keep it very simple, like we learned in Dr. Graves' course. Simple sentences, all laid out. So I laid out my experience, what happened. I put in some titles, subtitles to, guide the reader in what comes next. I have to go through the whole process of what I did, what led to this petition.
Take your time.
Well, I'm not going to read it, I guess, because it would take too long. So I'm thinking people can look at this, look at the video recording.
And it's posted in our Telegram chat, right?
No, I haven't put any of these documents in, so
Okay.
I would have to do that. But anyway, here's where it gets really, I put them on the spot. So, which is what? The 2016 order only causes further perplexity because there were rules of criminal procedure that they changed. So originally, Rule 542C5 says the defendant shall be present at any preliminary hearing except as provided in these rules and may may make written notes of the proceedings or have counsel to do so. So they may make written notes, or an electronic recording. So I witnessed the opposite of this rule. It was based on wait a minute. So it was based on 141C4, and it had formed the basis of this court case in Pennsylvania in 1977. And it admits that this memorandum, here, of particular importance, it is advising that defendants were not permitted to make a mechanical or electronic record. It's problematic because the United States Supreme Court has recognized that information presented at a preliminary hearing may bear crucially upon the accused defense. And there's the Supreme Court SCOTUS case in 1970. So then there's also a Pennsylvania Supreme Court case, Commonwealth versus McClelland, in 2020. Courts are bound to interpret a statute where possible in a way that comports with the Constitution's terms. But the real clincher is this Third Circuit case, Philadelphia Bail Fund versus Arraignment Court Magistrate Judges. And lo and behold, what I found out afterwards, this case involved the same lawyer as the one who wrote motion to dismiss against my petition. Yeah. So he knows what the Third Circuit has ruled, and specifically what they ruled, and I'll go through it. I have the case itself to show, but when you read through this, they're saying that the very rules that they gave me, rules 112C and 1910, were unconstitutional in the way they were applied in this particular case with the Philadelphia Bail Fund. So he knew that already.
It's always the ones that know.
Yeah.
That are breaking the rules.
Yeah. So I mean, this is it's just more crime upon crime.
And so you put no verbiage about discrimination in here at all? This is just, you're just, hey, these aren't the rules.
Yeah, I did. So but I basically ended like I didn't get. I'm confused with what case law that I read, and what I compared to what I experienced, and the respondent, Judge Hall, confirmed that a defendant may cause a recording. So there's too much vagueness here. Too much vagueness. If the public cannot understand, it becomes null and void. And then I also documented what happened with that CD, how it was inaccessible. So that's all in there.
Do you remember what file format it was in?
File format.
Last three letters of dot whatever, last three letters of the file.
And it cost me $2, by the way. I had to pay $2, and it's just a CDR disc.
Yeah, right. I was just wondering the file on the disc, what the last three digits were.
But I can't. But it's all audio, so it doesn't I put it in my CD player, and it just doesn't do anything.
Okay.
Well, I can't even tell. I don't know what it doesn't say what type of disc it is. So anyway, my prayer for relief is to avert vagueness and uphold equal protection.
Right. To
properly limit government to due process, abide by the First Amendment right to record a public event. So, you've pointed out that a judge can limit that, can set up parameters, but it has to apply. So, but to everyone, and but I am saying applicable to all participants right here.
Correct.
Applicable to all participants and witnesses of a courtroom proceeding. Yeah. So, here comes. So, let me show you first. Here's the Philadelphia Bail Fund case,
Okay.
and right here, Michael Daly, right here. He's the liar I'm up against, and he knows that in this case, these 112C in 1910 were unconstitutional as applied. In this case, the Philadelphia Bail Fund did not get access to the session, the court session. Well, neither did I, but he's claiming, Michael Daly, that I did because I got a CD. It doesn't matter that I can't play it in the courtroom, can't tell me that what software it needs.
Did you have to serve Michael Daly, or he just chimed in because he saw it in the court record?
So, well, when you file with the court, you have a certificate of service. So let's see. You put in a notice to plead to the to the respondent, and you have to, if it involves the Commonwealth, you have to send it to the Attorney General and the court administrator. And there's my verification of complaint, and certificate of service went to these people again. And then I get a notice of appearance. So it's filed through Pennsylvania has a PAC file system, they call it, for e-filing. And that's when I got notice of Michael Daly as the counsel for John Hall.
Okay. So John Hall was okay. So he's the counsel for somebody you mentioned in the declaration. I got you.
Yeah.
I was just wondering if
the respondent,
if he was just reading legal news and decided to jump into this, or he had a dog in the fight.
Well, he does kind of have a dog in the fight since
Right.
he knows.
That's
He knows.
That's right.
But anyway, he was, for whatever reason, he was chosen to be the counsel for John Hall, President Judge John Hall.
Okay, so John Hall's the president judge of the municipal court.
So there's the municipal courts, but then they're overseen by John Hall, who is the president judge of the Court of Common Pleas.
Gotcha.
So that's the next level.
That's the state court.
Yes.
I gotcha.
Yep. So there he is, Michael Daly.
Mm-hmm.
And he wants to get rid of this petition. And it was pretty lame. So I had to address each one of these lame statements. And I got the feeling that they lumped the public with the commercial. I got the feeling like, I like treating me as if I'm some newscaster with my whole Channel 5 coming in to record. No, I'm just public citizen.
Well, you're essentially a citizen journalist. I mean, that's what we're all tasked with. So it's really no different than the news coming in, except you have probably a smaller audience, but that shouldn't matter.
Yes, but do you think it's worth noting that I'm not a legal entity in this case? I'm just the public, versus statutes are written for. Okay, this is where I'm getting it clarified. Statutes are written for legal entities, but courtrooms have their own special jurisdiction by the judge in order to keep fairness of the court sessions, keep due process, make sure nothing gets prejudiced. So that's kind of like a special category where the judge can make rules. They're not statutes, they're just rules of the court.
Yeah, that's right. It's like judicial immunity. It's the same way it works. So as long as he or she is acting in the confines of the court case, they have judicial immunity. So if they have jurisdiction over the parties, then they can pretty much do anything they like with judicial immunity. At least on the federal level. I don't know about the municipal level, but it can't be discriminatory. So you can't have, we're going to allow these lawyers in here and do this, but here's the public's directive. That doesn't work.
it's just, yeah, like it's a really important point. Um, there's all these nuances and contexts that you have to understand in order to come to the right conclusions.
Sure.
Yeah.
There's
So,
all these, and it shouldn't be this way, but this is then judges making precedent and things, legislating from the bench essentially with all these doctrines. Well, this is how we're going to look at it this way, and and that to some degree that may be needed, but there's a lot more out there than we need.
yeah, and that's also what I'm learning about, like, the law, the fundamental law that this country was established on is being twisted or ignored by these subjective doctrines, well, and so it's gotten really fuzzy and gray and um, away from the principles of jurisprudence.
Yeah, it's it's
Uh,
it's a nuanced thing, whereas the Constitution is not nuanced at all. It's just blank,
yeah,
straightforward, and blunt.
yeah.
Whereas these judges have had to go in and create all these doctrines to make it nuanced and make it hard to.
So the Chevron deference doesn't apply to the courtroom. Like, in other words, the Chevron doctrine has gone too far, so that administrative rules are trumping prin- uh, natural law or jurisprudence. Um, but the um, but again, like you said, the judge, in order to maintain fairness, has to create rules. Okay, I'm just like,
No,
you
you
can
that's
just see,
you
keeping it all
got it.
straight.
You got
Yeah,
it. You got it. So the Chevron deference would only apply to the executive branch.
yeah. Okay,
Right. And
okay,
their agencies. So the judicial branch would be completely separate and not under any of
okay.
those guidelines.
All right. So I'm hoping that doing this video is going to like really be helpful for people to get their education underway too, to complement everything we're doing and learning. Um,
Absolutely. That's why we're here doing this.
yeah. um, so then the real throwing spaghetti at the wall here. Petitioner lacks standing, fails to state valid declaratory judgment, whatever that means. First Amendment or equal protection claims. The action is barred by sovereign immunity, and this court lacks jurisdiction to interfere.
Well, they're going to say that no matter what. So
Yep.
that's basically the same thing as saying failure to state a claim.
Yeah, which doesn't apply to a petition declaratory judgment. You're not making a cause of action. You're claiming what are my rights. You're claiming a question. What are my rights here? Um, so anyway, that was his preliminary objection. And oh, let's see. So I had to answer, and I titled it wrong because I didn't know any better. Um, so I go through every one of his statements and correct it, and give some more case law. Yeah. So,
Looks thorough.
uh, it's a lot of work, but it's a really good brain exercise. I can tell you that. Um, So I start off by saying the preliminary objections exude the same old tactics over and over again, um, where a citizen seeks to know the law and must deal instead with half baked, frivolous, unorganized, evasive, inadmissible, and irrelevant responses that avoid any clear, coherent, logical presentation of American jurisprudence. It's as if their legal education was a joke against this nation, not to mention against themselves after having spent all that money on tuition and books, room and board. I just couldn't help myself throwing an insult back. Um, so again, failed to answer the questions. He's claiming that I'm suing because he's responsible for the courtroom system and right to know appeals. When again, reality is that not only did I'm seeking clarification of the law, um, and I didn't get the respondent failed to provide that. Um,
Now, was there a fee to file this?
$72.50.
Gotcha.
Yep. See if there's anything here. Well, again, people can, when they're looking at the video, they can go through. But he ignored that. He didn't mention any in his preliminary objections. He didn't mention anything about the signs. So I made sure that I put that fact back in, put the facts back in. That's what I constantly had to do every time I wrote something. I had to put the facts back in that were ignored. Um, and he even claimed that I said that the lawyers and police officers were recording. And I never said that. That was not in my petition. So I had to straighten that out.
Oh, that's a standard operating procedure for
Yeah,
the lawyers.
they ignore the relevant facts and they add in non-facts and hearsay. Um, so I did put in here the respondent who oversees judges would do well to remember the petitioner is one of the sovereign people of Pennsylvania, having substantive, inherent, indefeasible, and inalienable rights, not statutory rights, granted by the legislature. And I quoted this Brown versus Commonwealth, which was is that an appellate case? Well, no, it's a Pennsylvania Supreme Court case, which upheld the Alphonse showed us this, and upholds the Declaration of Independence and the Pennsylvania Constitution Declaration of Rights. And I just learned the other day that this was written by one justice who was the only dissenting opinion in
Hmm.
that case. Did you see that? Someone posted it was just one judge's dissenting opinion from this case, not all the other justices' opinion.
Well, yeah. So typically, the majority make the opinion, and then if someone wants to, if someone thinks of points of law that may come up in future cases,
Yeah.
they write a dissenting opinion, for reference, and
Yeah.
either one is valid. Obviously the main opinion is a little more valid than this, but it's certainly if you were searching to overturn something, you would use those concurring opinions to do that.
Okay. Yeah, because I was a little bit taken back, like, oh, you mean so the case doesn't support this, only one justice supported it, but you're saying it has still merit. It still has merit.
Right.
The
Well,
one dissension.
right, and you could use his argument there, as basis for bolstering why you think it's unfair as well, right?
Yeah. Okay. All right. Now, of course, I don't think I'm going to put in this type of thing, sovereign people of Pennsylvania, again, because it's being weaponized. That term is being weaponized. So, I
That
don't.
it is.
Yep.
Even though it's the very definition of what the people are.
Yeah. So, what are you going to do? Um,
Well, the CIA and the FBI says reading source materials is now dangerous activity.
okay.
So
And
case
then
law and American jurisprudence and things of this nature would all be, no topics in reading for the American public.
So, by our putting this stuff on Telegram groups, it's almost like we're the founding fathers going up against King George. And we could be putting our lives on the line.
Lives, treasure, and sacred honor, I would imagine. But the reason we chose Telegram is because no bit of information has been turned over to government agencies through Telegram. It's a single owner, although he is Russian born. We just saw I posted an interview of him and Tucker Carlson the other day, and he is truly trying to be a free speech advocate, probably better than Elon Musk has been. He has a very, very, very small team that works with him, and he literally makes all the decisions himself. And he is appears to be a very neutral party, and he is this platform is the least amount of working with government agencies.
Okay. Good to know. So in my answer, I put back in what he left out.
Mm-hmm.
That was in my petition. He just totally ignored it. Again, reminding I'm seeking the law here. It very much appears that the respondent is desperate to throw whatever he hopes will stick against the wall, despite glaring double helix logical inconsistencies, as if petitioner's too stupid to notice. And then I go through what all his twisted
That's a great
crap.
line. The double helix. I love it.
Yeah. Yeah, spaghetti in a bowl, that's for sure. All right, so then we move to okay, so he turns out the one thing about his that he's right about in his preliminary objections is that assuming I'm interpreting correctly, because this is a judicial rule, not a statute, that the Commonwealth Court does not have jurisdiction. So all's well that ends well, right? It's even though I should have gone to the Pennsylvania Supreme Court first. It's all progressing just fine. Let me see. And he, in his preliminary objections, he said nothing about the case that he knows, the Philadelphia Bail Fund case. There's nothing in here. He doesn't reference it at all.
Oh, they're very good at avoiding the topics they don't want to talk about.
Yeah, and he knows that case supports what my petition.
Mm-hmm.
So then it comes time to write the briefs. The Commonwealth Court orders. I mean, I don't know why the Commonwealth Court couldn't have just said, "Hey, this is from the very start. This is not in our jurisdiction," and put the petition off to the Supreme Court from the start. Why didn't they do that? I don't get it.
Well, it sounds like
they wait a year.
Yeah, it sounds like they were delaying the proceedings because they don't want this to go up the chain because they may know what may come down.
Yeah. In fact, because I witnessed a defendant being under threat of arrest, they have to hide that.
Right.
They were wrong to threaten an arrest of a defendant for recording the session.
Yeah, so that's what. So Brandon in his wildlife fisheries case, he filed it in state court where it belonged, and then the state remanded it to federal jurisdiction because it had federal questions in it, and the federal judge, which is the one we're suing, Shelley Dick, she sat on it for over a year, and finally, the first thing she did was remand it back to state court.
Okay.
So it's just been a game back and forth. And then in our Marshall's case, our motions to dismiss have been finalized for over a year now. The judge won't rule on them. So they're just dragging their feet because they know they're not going to like the answer they get, or they don't want us to go up the chain.
Okay. And we have to go off the chain anyway. So then the Commonwealth Court orders briefs. Now, according to the rules, appellate rules, Chapter 21, you start with the brief of the appellant, which I was, the petitioner.
Mm-hmm.
The appellee responds, and the appellant gets the last word. Okay?
Right.
But instead, the court tells the appellee to go first and me to go second. And which was confusing because, especially since the brief of the appellant can be 14,000 words and the brief of the appellee can only be 7,500. So if you look at the rules.
Yeah, I'm just wondering if the declaratory judgment's a little different than actual appeal, and that's why they did it, or because that doesn't. They usually don't go out of rules like that, but
Yeah, so but it was confusing to me, like, well, then when it comes to the rules, for, like, what format am I supposed to use? Okay, let me go back here. I know this is confusing, but so, um, the reply how does it do it? So well, again, this is all a learning experience. So the brief of the appellant follows, from what I understand, you have to write a statement of jurisdiction. You have to pose the questions. You have to state the case, a summary argument, provide the argument. Um, you know, so does that apply to me or not? I made sure that I applied it to myself. Um, it's just so hard to follow everything.
Well,
That's
especially the first time. But I
yeah.
think what they're doing is they're treating what you filed in the lower court as your initial brief, because since the state court or since the lower court didn't have jurisdiction, that it basically be your complaint, your first complaint. So it's going up to the Supreme Court, and then they're asking for the response from the other side, and then you'll get to rebut everything that he says in a serve
Well,
reply.
see, they just said I could reply. They put me in the reply category,
Right. There.
but I didn't have a chance. Then I can't rebut the. Well, I don't know. I see. Here, Rule 2135. A principal brief shall not exceed 14,000 words, and a reply brief shall not exceed 7,000 words. So I'm limited in what I can say.
Correct. Correct.
But
So I think they're treating your petition, the first initial writing that you did, as they're treating that as your brief, and then you're going to get the response from your opposition, and then you're going to be able to reply after you
uh,
see what they've written.
so you're saying that my petition served as a brief,
I believe so. That's what it sounds like is going on here. I don't
but
know. I
yeah,
haven't read the
I
rules, but
don't know. No, because see that if I go further up, this chapter 15 is all about the petition.
mhm.
So no, the petition is not the brief. It's not the appellant brief.
But you didn't appeal, right? So traditionally, like, you would get a ruling from the lower court, and then you would give them a notice of appeal, and then you would write a brief to the appellate court. But that's not what happened here. It
Okay.
what happened here is they said we don't have jurisdiction, and they sent it directly to the court, the superior court.
No, no, this is before. This is the Commonwealth Court that ordered the briefs,
Okay.
not the Supreme.
Okay. And then they decided they didn't have jurisdiction, and then they sent it up the chain without a ruling.
Right after they made me write a brief, and of course the lawyer wrote a brief. Then a year later they transfer it to the Supreme Court.
And they're asking direct, and the first response that the appellate court's asking is from the defense.
Uh, the Supreme Court is just sitting there. The case is just sitting in the Supreme Court, and they haven't ordered anything.
Okay, well, let's see what documentation they send you first before we make any rash decisions here, because normally you don't get a sur reply in the lower courts. It would only be in the appellate court you would get
But
a sur
okay,
reply.
so the Commonwealth Court though is an appellate court. In Pennsylvania, this appellate court also has original jurisdiction. It's something weird in Pennsylvania, I guess. So the Commonwealth Court has original jurisdiction and appellate jurisdiction. Because I didn't have a government order, it was in original. I wasn't appealing a lower an administrative order. So that would have put it under appellate jurisdiction. I was just asking for a declaratory judgment, which puts it under original jurisdiction,
Okay.
but it's under appellate rules that the clerk told me you have to follow, even though your original jurisdiction, you have to follow appellate rules. So
All right. Well,
that's
it sounds like I would need to read the rules to figure all that out, or wait for the appellate or the Supreme Court to send you a packet. Normally they send you an initial packet
no,
telling
no.
you
I'm
how it's
I'm
going
not
to go.
at the I'm not at the Supreme Court. I'm still in the Commonwealth Court phase here. Don't go to Supreme yet because I'm just dealing with my process with the Commonwealth Court.
I got you. I got you.
Yeah.
Okay.
So yeah. So if I were to scoot up here, chapter 15, it tells you how to do the declaratory judgment. 15. So I had to, read through all this. It,
Sure.
it was quite a lot of work. So petition for review. Um, so to me, the way this should have gone is you put in your petition. If a lawyer puts in a motion to dismiss, I should have put in a motion to strike. It shouldn't have gone this. It should just be a simple petition and get a ruling on it. But I just learned today I could have, by reading 7532, that I could have put in a motion to strike.
And maybe the next person that does this won't make that mistake. So these
Yeah.
are all helpful helpful tips. This is why we're here. Why we're here.
Yes. Yep. So I shouldn't have had to go through answering preliminary objections, and I shouldn't have had to go through writing a brief. Anyway, I did anyway. Good practice.
Mm-hmm.
So here's the brief, and he talks about her interpretation of permitted cell phone use. Well, there was no permitted cell phone use in that, according to the courtroom sign. And we're not talking about my interpretation, we're talking about a courtroom sign. And I'm just a spectator. The words they use are so disdainful. And her purported constitutional right,
Yeah.
purported means it should be protected constitutional right. Yeah.
They're very dismissive.
Oh yes, and disdainful. And so I did notice he fixed his hearsay. He did finally admit that there were signs in the room. Um and that to see two signs. He finally admits it because he's responding to my answer. Well, I mean, this is his brief, but in other words, my answer told him, "You're a jerk. You're leaving stuff out that is relevant." So in his brief, he puts it back in to save face, I guess. And instead of saying that I said that the attorneys and police officers were recording, I didn't say that. I said they were looking at and interacting with their cell phones. So he finally fixed that. And yeah, and that the constable didn't say I couldn't. He said in the objection that the constable told me I couldn't use my cell phone. No, she told me I couldn't record. Okay, so he fixed his errors, and he did fix a bunch of things. And it's not because Judge Hall denied my appeal, it's because he failed to answer my questions. That's why I am doing a declaratory judgment. So anyway, then his big excuse is that hey, she had access to the courtroom session because she got a CD. Doesn't say anything about that. The facts that it was inaccessible. I couldn't play it. Okay, yeah. So again, he's trying to pretend that that the judge did his job, and answered my right to know request, and therefore I have no reason to be appealing. But the fact that in the judge's answer to my appeal, he said a defendant may record. That's left out. Because again, they're trying to hide the fact that they committed crime in that event. They put a defendant under threat of arrest when they should not have. So they're trying to hide it.
Do you know that defendant?
Um, that defendant is someone who I think wants to remain anonymous, so I keep it that way. Um, but it's someone in Pennsylvania who could be in prison now. Um,
Well, if you put your head in the sand, they're still going to come for you. It's just going to be later.
yeah. Oh, you're referring to that? I know I didn't speak up because you're referring to that saying. I didn't speak up, but then they came for me, and there was no one to speak up for me.
There you
Is that?
go.
Is it? Yeah.
There you go.
Yeah. Um, he tries to again defend 112, Rule 112. Um, but again, it doesn't answer my question. And he knows it can't. He knows that Philadelphia bail fund case. And let's see. She. I'm asserting an equal protection claim, apparently based on an allegation that attorneys and police officers can look at their cell phones in the courtroom, but the public allegedly cannot. Um, that's not what I said. So he's still making that error and um, denying my petition.
Yeah, we even had some assistant U.S. attorneys alter case law. They changed the words in the case law that they cited, and we caught them. And judge doesn't care.
Yeah, yep. But again, you have to go through every step of getting the facts on the record for appeal.
That's right. That's right. Just
And,
make the
and
record.
yeah. Again, he likes to think that I lack standing to challenge cell phone use. He just diluting the petition. Like I'm just challenging cell phone use. Okay. In the sense I am because there's a sign in the courtroom that says no cell phone use. Okay. And then I lack standing because I have no allegation of future visits where I would be subjected to such policies, and therefore I do not have an immediate concrete interest in how cell phone use is administered. Yeah, that's what he says. And there's no uncertainty about any legal obligations between the parties. Yep, no uncertainty. There's no First Amendment, right? And so I lack standing to challenge cell phone use because there's no contention I will visit the court again. Lack standing. Yep, he just repeats the same old garbage. Um, Thus, I can't be injured by how the court operates administratively. Okay. Then his next, it turns out this argument was right that it had to be the petition had to go to Supreme Court. But again, use of words. First Amendment purported right to record a public event. The word use of purported. It's just like I said, disdainful.
Don't get all tied up in their lane. They're going to paint you in the worst possible
Yeah,
picture,
yeah.
and it's your job to bring the case law and the facts and put the judge in a corner and tie his hands.
Mm-hmm.
That's what your job is.
Mm-hmm. Yep, and it's a big job, isn't it?
It is. It is right now.
Okay, and then he has more arguments here. Declaratory relief is not appropriate. Again, to cut to the chase of this, cut to the short, all these arguments when were not addressed by the Commonwealth Court because they're meaningless. They knew they couldn't address them. They just all they centered on was the fact that this argument here he was right. The case needed to go to the Supreme Court.
Right.
But it just goes to show you that uh, you just have to deal with a lot of bull crap.
That's right. But look, be thankful that they gave you the year to study, right? I think you probably learned some things between then and now.
Yep. Now here he does admit the Philadelphia bail fund case. He finally admits it. But he's saying it doesn't apply because I have I have the CD. So does it matter to the court? Does it matter to the Supreme Court that they give me a CD that I can't play because I need special software to play it, and they won't tell me, they don't know what that special software is?
Well,
Does that will the
when you
Yeah.
make your argument to the Supreme Court, which I assume you haven't written yet, right? Or have you?
No, because it just got transferred a
Yeah.
couple weeks ago.
Okay.
And by the way, I just got a letter yesterday. They're treating it as a petition for writ of mandamus.
Okay. Well, when you make your argument, your next argument, make sure that you focus on equal protection and discrimination laws, right? Because that's what's happening. Whether you got a CD or not, well, all these lawyers and cops can use their cell phone. Why can't you use yours? Why is there a double standard?
Mhm. Okay.
And that should be your argument going in: discrimination, unequal protection.
Okay. Um
On top of what you already have. I mean, you're doing great. You're doing great.
yeah. Now, the thing is, in that Philadelphia case, bail fund case, um, the quality. Well, I have to show you. In Often these recordings are just for internal use only, and they're not very audible. And so that's maybe what they gave me, was just their internal use CD, and they. So it's, if that's the case, it's not publicly accessible. Um, so he wants to think that my First Amendment claim is meritless because I have the CD. Um, the petitioner had technical issues with the recording. It does not make a constitutional claim. Well, that's not like it's my fault that I have technical issues. No, it's that I was told there's special software, but I don't know what, they won't tell me what it is. So he left out those details.
Yeah, I
Um,
would I would definitely add that in. Say the court could even tell me what software I needed to play these audio record. How?
yes, and I put that for sure in my brief. In my Yep,
Mhm.
I put all those details, all those facts back in that they're trying to avoid. Um, Petitioner's claim is not based on a protected class. Thus, she must establish a class of one claim, which requires a showing that she was intentionally treated differently from others similarly situated without a rational basis.
Well, your intention were to record the proceedings, correct?
Well, yeah, I would have, other than I didn't want to get arrested that day, so
Right.
I
And
I
and you
didn't.
saw a chilling and deterring effect in front of you, and said,
Yeah.
"Well, I'm not going to do. I'm get arrested just to." So we want to clarify this law, because I was basically threatened with arrest too, because I saw a chilling effect in front of me.
Oh, and so what he's trying to narrow it down to, like, that I couldn't use my cell phone. And no, the point is I couldn't record.
Right.
So see
Uh,
what he's doing here? See what
of
he's
course,
doing?
yes, of course, they're going to parse it as fine as they can,
Uh-huh.
and that he has a little bit of ground to stand on there. But if your intentions were to record and you saw someone threatened with arrest for doing so, then no, you wouldn't want to do that. Your rights were chilled and deterred by that action.
And the fact that there's a sign in the courtroom that says no cell phone use.
Right. And that too.
That too. What's the sign doing there then? If I could, basically what he's saying is I could have used my cell phone just like everybody else in that room.
Well, then why the signs that you would say we can't?
Yeah. So everything's vague.
Mm-hmm.
Okay. So let's see. I failed to state a due process claim.
Well,
And
that's
he goes
probably
into,
true.
well, yeah, because it's a petition, not
Yeah. Yeah.
a complaint.
Right.
Yeah,
They didn't
that's
arrest
what.
you. They didn't give you a summons, anything like that.
Yeah.
There's no due process needed here. But I had a chilling and deterring effect of my constitutional rights.
Okay. And so yeah, he goes into, it must be the conduct must be conscious shocking. Well, he's right. There was nothing conscious shocking about it except the chilling, deterring, and the vagueness. That's all. Okay. So, and he even uses this exhibit that shows. See, he shows that the defendant had a right to record. Does he address that in his? Nope, nope, it's nowhere in there. In fact, he says in a footnote. Moreover, whether the judge in the proceeding petitioner witness did not allow the defendant to record the preliminary hearing is of no moment to this action. Well, okay, I'm not the defendant, so I can't claim it for that crime for myself. I'm not the one who suffered it. Um, I'm asserting it on behalf of a third party, but nevertheless, it's still an important fact as to why I did a declaratory judgment. And
Yeah, that's what you use to say my rights were chilled and deterred by the action that happened in front of me,
Mm-hmm.
and that's why you're bringing that up.
Mm-hmm. Okay. So here's my reply brief. And I went through the rules of appellate procedure and I made it an appellant brief. So I did everything because I want to encompass all the facts that need to be encompassed with case law and, everything that is relevant to to adjudicating. And so I did scope of review, made sure all the details are there, standards of review.
Well, would you be okay, since you've got all these documents redacted, to put them in the document resource section on declaratory judgments?
Yeah, so it would have to be like, yeah, yeah.
Oh.
Is it like a folder you can put them in, or just list them?
I don't know if you have permission to post in there or not, but either way, I can either give you permission or you can send them to me and I'll post them for you. We don't want all kinds of documents posted in here that contains God knows what. So
right. All right. Well, just some highlights. Statement of the case: stubborn facts that cannot be ignored in a court of justice and equity under the heritage of American jurisprudence. I'm just, I word things to just make that, to instill that this is serious, and I'm trying to follow the law. So the court needs to do the same. That's what we have these courts for. So I have to address in my argument all the failures in the respondent's brief. That's what I do. And how he waters things down and omits, denies, all that. Get it all in there. Misuses case law. And in fact, the case law he quoted, when I read it, it actually supported my petition. So I made sure to put that in.
Lots of times they do that, and they hope the judge doesn't read it.
Yep. Now, this is the best part. Now, this comes from having the year to study and learn and watch your videos and read all the posts. So I made an argument. The people who use their noggin know better and even more. Number one, the hierarchy of law must be followed. And go through that. Number two, the hierarchy of law protecting the people requires simple language and meaning to avoid vague, arbitrary, deprivational, discriminatory results. And I go through that. 3, maintaining the rule of hierarchical law in practice means, we have the strict scrutiny test, and I bring in the Philadelphia Bail Fund, throughout this argument, because it supports my petition.
Just subtle jabs there at him.
Oh, yes. And what's really great about it is that the Third Circuit used the Philadelphia Bail Fund to in its cases. So we're dealing with the Federal Appellate Circuit supports my petition as well. So you can see why they had to give this case to the Pennsylvania Supreme Court. They have to deal with it. How are they going to handle this? It's going to be very interesting. Um, Again, all these important cases. And number 4, the people of which petitioner is a member have unceasing societal interests and thus personal interests, which First Amendment protects, such as the dissemination and publishing of public events which cannot be granted by government. Um, I use maxims, and here, this case, United States versus Simone, 6 societal interests in support of open courtrooms. Again, quoting Philadelphia Bail Fund. Um, so let's see. Promotion of informed discussion of governmental affairs by providing the public with more complete understanding of the judicial system. Promotion of the public perception of fairness, which can be achieved only by permitting full public view of the proceedings. Providing a significant community therapeutic value as an outlet for community concern, hostility, and emotion. Serving as a check on corrupt practices by exposing the judicial process to public scrutiny. Enhancement of the performance of all involved and discouragement of perjury. Yeah. So then, just see again, Philadelphia Bail Fund. Also, another case, Third Circuit. So yeah, it's pretty good argument. And I think the last one, statutes address legal entities and an absolute necessity of jury seclusion in the interest of justice, not the people quietly recording a public hearing. So again, maybe this is where I'm thinking this is where you're giving me a little bit more nuance to this argument, that a judge can set parameters. It's not a statute we're dealing with. We're dealing with judicial administration. So let's see. But I'm going to go through the Philadelphia Bail Fund case because, for instance, here courts are fact-finding institutions, which after due deliberation, what I'm trying to find is where they say recording is important.
Yeah, I think the American Jurisprudence on Judges is posted, and that contains a section on judicial immunity. And judicial immunity is very close to how they can control the courtroom, and it probably will give you a good understanding of the nuances there involved. And so you might want to check that out.
Okay, I'm saying name that again. What should I check out?
So the American Jurisprudence on Judges.
Okay.
There's a section in there on judicial immunity.
Okay.
You can and it explains the differences in what the courtroom means during a court session and what the courthouse means, right? As administration, that type of thing. So it'll give you some indication in there, and all of our stuff in the U.S. Marshals case on the anything pertaining to the judge and not the U.S. Marshals or anything like that is very relevant. Get some Supreme Court case law in there about that as well. So, but that just gives you the definition of why they can control the courtroom with actors that they have jurisdiction over, whereas they can't control the public just entering the courthouse, right?
Mm-hmm.
So the judge could ban it, but not under equal protection, allowing the police and lawyers to use their phones. But so it just might give you a better understanding of the nuance there, right?
Okay. All right. And then the court CD is unreasonable, making public access an unreasonable impossibility, violating the First Amendment. I had to make sure to put that in because they're trying to ignore the fact that the CD it doesn't play. It's just my problem.
Well, the court may see it that way, but we shall see.
Right. So yeah, here's something important. This comes from that case, Philadelphia Bail Fund. There's no transcript Although the court makes audio recordings of these preliminary arraignments, it does so to address technical issues such as the quality of the sound and to enable the president judge of the municipal court to monitor the performance of the magistrates. The recordings are not filed of record and are not used in making a bail determination in any case or in any subsequent hearing or for any appeal. The recordings are not available to the parties or the public and are of inferior quality and often hard to hear. So I just don't know what they gave me, whether it's just a, bull crap piece of um, evidence or not. I don't know. And so then I because I didn't I limited this brief to under 7,000 words. I decided to do a motion for sanctions with the other addressing the lawyer's barratry using these cases. Sanctions are available for a variety of types of willful actions, including recklessness when combined with frivolousness, harassment, improper purpose. And now that I know Daley was the one of the lawyers in that Philadelphia bond fund, I could have said he knows
Right.
what he's saying is all just barratry. But this motion for sanctions, it was denied. So it's okay for Daley to do these kind of behaviors. It's okay.
Yeah, they're I believe the courts are pretty reluctant to hand out sanctions except for really egregious stuff. But so you can also go into the rules of professional conduct and quote some of those, what he's done, and then basically copy and paste that and send it to the bar.
Well, I did, and of course, everything was denied.
Well, no doubts, but
yeah, no doubt, right? But yeah, again, making the record, and okay, so here we have the order from the Commonwealth Court. Opinion not reported, per curiam. Okay, so no one particular judge is listed, and so we sustain. Oh, you're gonna say
none
something?
of them wanted their name on it, I believe.
Exactly. we sustain the preliminary objection, which is a motion to dismiss, contesting this court's jurisdiction, and transfer the matter to the Supreme Court. So,
and it took them a year to do it.
Yeah, but it's like talking out of both sides of their mouths, isn't it?
Well,
because they didn't get rid of it. I have too much case law in there. I have too much facts in there that if they deny it, that their crime is quite obvious. I'd like to think of it that way.
Yeah, well, look, let's take it to the limit. Let's see what happens.
Yeah, and they don't, and they say the lawyers and police officers ignored the two signs. Yes, but also the judge didn't enforce the sign. They do mention the Philadelphia Bail Fund, but they don't discuss it. Just keep it real curt and because they can't discuss it. They know they're up against the wall. So fail to allege future visits, giving me no standing, that there's no uncertainty about any legal obligations between the parties, failing to state First Amendment, equal protection, and due process claims. They don't even discuss it. They just leave it hanging.
So now you have all their arguments for the next case, for the next writing, and you just make sure that you address all those topics. No problem.
Yeah, but I think it's just so interesting that
right.
they can't. It is what it is.
Well, they're just looking for a technicality. They're looking for any little hole that the judge can escape from, and that's sadly what we've seen, especially with these activist judges. And sometimes they don't even look for a hole. They just don't rule. We've had we've had injunctions denied with no findings of facts and conclusions of law, which is required by Rule 52 of the FRCP. But they just flat out refused them when we objected to the judge. Said, no, we need you to provide these things as required. And he said it's premature.
Okay.
Well, it's not premature to rule, but it's premature to give us the reasons. Okay.
Yeah.
Right.
And then here's something else that's funny. They gave me the benefit of the doubt. So in other words, they used a court case, the Garasi court case in court to say Commonwealth Court doesn't have jurisdiction. Okay. And then they threw out the Garasi case. But they're giving me the benefit of the doubt. So they're not going to throw it out like they did in the Garasi situation. Because the Garasi, he didn't, that petitioner didn't use the petition correctly. So they had to throw it out. I'm using it correctly. So they're giving me the benefit of the doubt.
How benevolent of them.
Yes. So nice. So that's it. The preliminary rejection grounded in lack of jurisdiction and transferred the matter to the Supreme Court. And so because this order left out a lot of details, I just wrote a judicial notice to preserve, correct, include material facts and law in concise summary, and provide it. And also what I did was include all the exhibits of which I show that I went to the DA with a private criminal complaint, that, hey, I have this letter here from the judge saying a defendant may record their hearing. And I witnessed a defendant under threat of arrest for recording. That's an obstruction of justice. I forget, I used two criminal codes when I sent my private criminal complaint. And the DA sent it back, lack of prima facie evidence, even though I included the letter.
Mm-hmm.
And so I sent it to the AG, and they sent it back. Yeah, and I included, when I sent to the AG, I also included a private criminal complaint on the DA. So it's like providing the evidence leading towards, however long this has to go. But RICO is happening here, learning from Seraph's strategy. So,
well, yeah, look, it's just keep documenting, and at some point, whether it be in this case or future prosecutions, sooner or later, it's all that's going to catch up with them. Sooner or later. So we're doing the Lord's work here. Whether we see the outcome or whether it's what we want at the time is different.
Yeah, we have to just rely, like the founding fathers, rely on divine providence and just keep going.
That's it.
And I really. Oh, go ahead.
No, you too. You go ahead.
Well, I want to also say that in starting out this whole process since 2021, I have really felt divine providence at work in a myriad number of ways. So it's, and I say that for encouragement. It's scary to do this. I remember trying to decide, am I going to fight that speeding ticket or not? It's so much easier just to pay it. But I just had, it was like I prayed about it a lot, and I just, that impulse in me to fight was still there. So I did, and it was quite a process, and it's just gone on from there. As I told you, I had situation after situation to handle, to learn this, and I'm still learning, even by doing this interview with you. I'm still learning. So
well, we all are on that page, and that's a great sentiment to end it on. I have one last question. I'm gonna give you the final word. During this whole process, has any of it been fun or satisfying?
Yes, because you laugh at their stupidity, and it's good. Like I said, it's good brain work, very good brain work. And like I said, because the divine, you feel like you're not alone. People post things on the Telegram channels. It's like, that's just what I need, or that just helps me understand what I'm figuring out, and we're all in this together. We're all working together, and trying to, and being someone who loves my country. Feel like I'm doing something very very important.
Well, Gopher, I really appreciate you coming on and sharing your story and spending your time with us. And I know that there'll be a lot of people that get a lot out of this. This is a perfect example of what we need to be putting out.
That's why I contacted you to share it. And yeah, um, can we
Oh.
stop recording?